Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome back once again to Legal Ease, the show that converts legal jargon into legal ease. If you've been following our Twitter feeds and our Facebook posts, and inshallah, hopefully you have now become accustomed to doing so, you will see that tonight's show is a general show. The title of tonight's show is Ask What You Want and We'll Answer Where We Can. Now, the reason for this general show is, as you will remember, is something that I stress on this show, is that you, the viewer, are the important person. The guest that we have on the show is usually also very important, but he's also just here for you. So we get a lot of calls, a lot of inquiries, a lot of emails from viewers asking about certain general topics. And since we can't necessarily utilize that topic to run a whole full spectrum show, we utilize these types of shows, general shows, and we get general specialist attorneys to answer some of the questions that you might have posted or might have emailed to us. So for tonight, we have a couple of your questions, but we're going to open the phone lines early. We're going to open the phone lines from the start of the show within the next few minutes. And once those phone lines are open, we'll be ready to take your calls, your tweets, and your posts. And we will then try and answer whatever questions you may have as best as we possibly can. Remember at all times that you have an obligation to yourself to make sure that the information that you're receiving on the show is in fact true and accurate, and to expand on that information. Remembering also that the phone calls are quite short. The show is only an hour long, so we can only impart certain information and advice to you, and it might not be completely 100% holistic. So inshallah, we'll do the best we can. And to assist us tonight, we have an attorney who is, as I say, a general specialist attorney by the name of Naeem Rajah, and he's an attorney who operates out of Rivonia. Assalamu alaikum, Naeem. Jazakallah for joining us on the show.
Wa alaikum salam wa rahmatullahi wa barakatuh. It's my pleasure. Thanks for inviting me.
Now, just as a note, Naeem has given up something very big to be on the show tonight, so ask as many questions as you like to make sure that his time on the show is as worthwhile as possible. Is that okay?
Please.
Jazakallah. Naeem, just quickly a bit about yourself. How long have you been in the industry? Where did you come from?
I've been in the industry for approximately 4 years now. Started off as primarily a criminal attorney, but we've slowly branched out now, and we are addressing all sorts of different aspects of the law at this stage.
Good. And you say you're still in the younger years, so it's good to get your hands on as many things as possible, and that's, I suppose, how we learn, right?
Absolutely.
And it's very important that we have attorneys like Naeem on the show, because it is also something that is important to promote our fellow brothers in the fraternity, and as well to give a different perspective, different advice to our viewers. Naeem, what's important and interesting is that you came out of the Ruber Magistrates Court, so you were hands-on, you were at grassroots. Just take us through that.
Definitely. Well, I started off as a public defender. I worked with legal aid. By that, I mean we offered legal services to people who can't afford appointing their own private attorneys when they have certain issues that arise. Primarily at the Rudderport Court, we were dealing with criminal law, and yes, we would assist them in that regard.
This is the caliber, to be honest, you're the caliber of attorney that we want on this show, because it's very important. It's something, again, that we stress time and time again, that this show is for you, the viewer. It's for the layperson, the man who wants to know something but can't afford to go out and get it. So we get specialists like you to come and assist us for free. We don't pay Naeem, we're not paying him 1 single cent, although we probably should. And inshallah, let's see where he takes us. There's a couple of points for discussion. The phone lines, by the way, are open. The number to dial, as usual, is on your screen. It's 011 086 7700. Please start dialing and get as many calls in as possible. And obviously, as you know, the phone lines do get busy, so we battle to take all the calls. So let's see how many we can field tonight. And also another reminder is that Naeem's email address, if you want to contact him after the show, is naeem@mnrajahattorneys.co.za. That's Raja with an H, nmrajahattorneys.co.za. And his landline number, if you want to call him, is Johannesburg code 011 234 1143. So that's 234 1143 Johannesburg code. You can call him and email him after the show if you have any other questions that are unanswered. So whilst you guys are dialing, we are going to be having a bit of discussion on a couple of things that have come onto the show, if that's okay.
Excellent.
Naeem, one of the things that was really pressing was the issue of sale of property. We've got quite a few calls relating to the sale of property. So specifically relating to when can a consumer, a purchaser, cancel or revoke the sale. Alternatively, when can a seller cancel or revoke a sale?
Well, in terms of the Consumer Protection Act now, it would also depend on the threshold, or the amount in question with regards to the property being sold. Up until 250,000 Rand, the purchaser does have 14 days after the signing of the offer to purchase to actually cancel said agreement. Things that do pop up otherwise, if you look at the actual offer to purchase that is signed when somebody does look to purchase a property, they do often contain things that what we would call suspensive conditions.
Right.
And these conditions essentially, for example, would be a bond. So you would say that I wish to purchase this house, but I would only do so if I do get the bond. So you know that if you don't get the bond, you have a right to cancel the agreement.
So it's a benefit to the purchaser in that instance.
It is indeed. It's to protect the purchaser.
We have a caller on the line, Naeem. So let's take this call and see what question we have and how we can answer. Assalamu alaikum. Good evening, caller. We're standing by.
Assalamu alaikum. Am I speaking to the right person?
Ji, inshallah. How are you, sister?
See, I'm fine, thank you. May I ask you a question, please?
Ji, please.
I just want to know, if we want to evict a tenant...
Sorry, sister, can I ask you if you can just turn your... Sorry, sister, can I ask you to turn your TV down, please, because we can't hear too clearly?
My TV is totally off.
Okay, all right, go for it.
I just want to know, in order to evict a tenant, right, with relative grounds, of course, I just want to know, does the Master of the High Court not do it? For us, I mean for free. Must we have to go, do we have to go through an attorney to have it done?
Okay.
Or through specialists or something?
Okay, Jazakallah, sister, we'll answer your question off air. Jazakallah for the question. Naeem, something that comes up often on the show regarding eviction.
Absolutely.
And, you know, something that's always attached to eviction is the cost. You know, it's quite a serious cost. I mean, I don't believe the master can do anything in that regard. I mean, the master of the High Court or the High Court itself. But again, being a legal aid attorney, I suppose you have the perfect answer for somebody who can't afford it.
That is exactly the situation. If you cannot afford a private attorney or to appoint a private attorney, there are institutions like the Legal Aid of South Africa, and certain universities do have law clinics who do actually specialize in assisting people who can't appoint their own attorneys with such things. In this regard, yes, it is not something easy that can be done, especially the evictions. It has to be done in terms of the legislation, the Prevention of Illegal Evictions Act. And you basically start off with a letter of demand. You have to demand that they leave the premises, obviously setting out the relevant reasons for it. And if the demand doesn't work, then you would have to go and start the legal process. There are very specific aspects that do make eviction process different to normal litigation processes, specifically time periods. You have to prescribe to specific time periods as set out in the Act. But that is essentially it. You just have to follow the procedure, which is starting off with the letter of demand, giving them an opportunity to get out within a reasonable time, obviously. And there are various aspects that you would have to take into consideration, specifically the age of the tenants, whether there are any children, the possibility of them finding alternative residence. And these are all the things that would be addressed if the tenant fails to actually leave the property, and when you go to court. And
after the notice period expires.
After the notice period expires.
And unfortunately now, from a cost perspective, I mean, there is an avenue within the Magistrates Court, I believe, that you can, and we've done it before, fortunately, to evict tenants in the Magistrates Court. It's just that magistrates are a little bit more iffy when it comes to applications for eviction in the Magistrates Court, because it's actually on a summons. You're actually lodging an action, which is funny,
yes,
as opposed to the eviction application in the High Court, which is, as you know, as you say, very costly. Jazakallah for that answer, Naeem. Let's carry on. And we were talking about property. Now we're going on to the issue of the sale of second-hand motor vehicles. One of the questions that came up ultimately was, I've bought a vehicle from Mr. X. I paid him X amount of money. I've received, in some instances, my car papers, registration papers. I'm driving through a roadblock. The police tell me, hold on a second, this vehicle is stolen. We're now going to arrest you. Is that possible?
Unfortunately, it is indeed possible that the driver of such a vehicle would be reasonably suspected of driving of being in possession of stolen property, and that in itself is a crime, suspicion of being in possession of stolen property, and as such, you would have to provide answers. That is the crux of that specific crime. If you can't give a reasonable explanation for why you are in possession of said property, then you can be found guilty of that crime. So in that regard, in that specific scenario, I would say prevention is better than cure. Islamically as well, we have to reduce all of our agreements to writing. This is for certainty, this is for clarity going forward. So if a police officer comes up to you, says your car is stolen, you can go home, pick up the contract that you signed and present it to the police officer. Say, on this and this date, I bought this car from this person, bona fide, I paid that amount of money for it. That is the reason for this vehicle being in my possession. And that should satisfy the criminal element of it. But obviously, if you've now paid money for a car that's going to be taken back from you and given to the rightful owner, you are going to be out of pocket.
Yes, of course.
That creates civil liability on the part of the person that sold it to you.
Yes.
So as a result of you having suffered damages, you can lay civil proceedings against the person that sold you the vehicle and get your money back.
Good, good. Thank you very much. And just a reminder as well that the phone lines are open. Obviously, the number to dial appears on your screen, 011-086-7700 or 1 or 2 or 3. And also a reminder that Naeem Rajah is the attorney that's sitting with us tonight, and his email address is naeem@mnrajah, Rajah with an H, attorneys.co.za, and he's also got a landline number which appears, and that number is 011-234-1143, and you can ask him any questions that you might not be able to get answered on the show tonight. Moving on, Naeem, and sitting with an issue from a criminal aspect, something quite peculiar, which is that issue of vigilantism. Now, it's not really. You might not have come across it in your time as an attorney, and I certainly actually have never represented a vigilante. But is it really that complicated? I mean, vigilantism. Can this person get prosecuted, and how, and in terms of what?
Oh, absolutely. If somebody decides to go and take the law into their own hands and commits a crime in doing so, they will be held criminally liable for such an act. Obviously, in criminal law, you have things called grounds for justification. So you may have committed a criminal act, but you do have legally justifiable grounds for having committed said act. The obvious one, if we're talking vigilantism, you wouldn't really suspect that it would be in private defense. If we do look at private defense, there are certain elements that have to be satisfied in order for private defense to be applicable, which is the threat that you're trying to prevent must be real and imminent. Real and imminent.
Absolutely.
So it can't be, you can't just
perceived.
think, it can't be perceived. I can't just think, hey, that person's going to shoot me. Let me just preempt him and shoot him back.
Yes, shoot him
Don't
first.
shoot him first to prevent it.
Yes.
There has to be a real and imminent threat. That is the largest thing about private defense. But
so that actually almost brings us back to the Oscar trial, if you really think about it. But we'll get to that. In the meantime, if you don't mind, we're going to take a small commercial break, and we're going to satisfy our sponsors. As I mentioned, we are sitting with Naeem Rajah. We're talking general law. Ask what you want, and we'll answer where we can. The number to dial when we come back, 011-086-7700, 1, 2 or 3. Jazakallah. Stay with us. We'll see you all shortly. Assalamu alaikum. Assalamu alaikum, welcome back to Legal Ease. As I mentioned before the break, we are sitting with Naeem Rajah, the attorney at MN Rajah Attorneys, and we're talking general law. Ask what you want and we'll answer where we can. As I mentioned, and a reminder, the phone lines are open, 011-086-7700 or 1 or 2 or 3. And of course, as you know, we are taking your tweets. We have a couple of tweets already and a call on the line. Naeem, let's take this call. Assalamu alaikum, good evening, caller.
Hi, good evening.
Yes, good evening.
My question relates to prescription.
Okay.
yes.
My employee of mine, her house was sold in 2007 by the bank.
Right.
Right? They then contacted her in 2011 saying that there is a residual amount owing. Now, between 2007 and 2008, I've asked the bank for any proof that they've contacted her in those 3 years.
Right.
They're unable to produce that. and she has not made any payments in that period. Does this not mean that the debt is prescribed?
Okay, there's quite a few things that we can discuss on there, so we'll just take it broad spectrum if you don't mind, caller, and if you don't mind, you can listen off air. But we'll go in a bit of detail to that. We'll try and cover all of it because we can't necessarily ask questions and receive that. Thank you very much, caller. We'll take your question. We'll answer your question. Naeem, so as I mentioned, quite a few things.
Yes.
Quite a few things, because remembering also that, just as a starting point, prescription starts to run from the moment that the cause of action becomes discovered. So in a situation with the bank,
the debt becomes due.
the debt becomes, well, at the time that you realize that the debt is not going to be paid, you now have a claim.
Right.
Right. So because let's be honest, the bond is everlasting. It's a 20-year loan. So if a bond installment carries on, it's only at the time where you realize the payments are not going to be made that you now realize that you've got a claim. Right. And also in the terms of a bond, if I'm not mistaken, it's when you either when you decide to cancel that bond, or if you don't want to cancel that bond, you want to claim damages on that bond, on the outstanding bond at least.
Are you talking now from the perspective of the bank?
The bank, because he's an issue of the bank. The
Okay,
bank
from what I understood, it was his employee was the owner of the property.
Yes, and the bank repossessed the property.
Bank repossessed the property. So that would mean that the outstanding funds that had not been paid over to the bank is what was actually claimed by the bank.
In 2011,
in
yes.
2011.
That was the residual that he was referring to. So basically in 2010, the property was sold. 2011, the bank came back and said, hold on, we sold your property for 400,000, argument's sake. There's still 100,000 outstanding. We want that money. What the caller is saying is already in 2010, when they executed on that property and actually repossessed it and ultimately sold it on public auction, would the debt have prescribed? If the debt arose in 2007, then they had up until 2010, obviously depending on the month, but they had exactly 3 years to claim on that debt. Is that correct?
Yes, that is definitely so. But from what I would understand is if the house was actually sold in execution, that means that judgment would have had to have been obtained already.
And summons obviously
instituted. Summons already was instituted.
And which interrupts obviously.
So the prescription was interrupted already. Unfortunately for this caller, the prescription is not in question here because judgment was already obtained. If judgment had not been obtained already and summons had not been issued yet, then of course we could look at the prescription period. But under those circumstances, unfortunately, that's not something that can be relied on.
Yes. Bear in mind, of course, there's a few other elements in this. I said we will talk a little bit of detail about this, and I think it's important because it's something that affects all of us as consumers. We sitting here, them sitting at home, even some bank managers and CEOs are consumers, if you think about it, because we all have bonds and we all have cars to pay and credit cards and so forth. What's important here is not necessarily whether or not the matter is prescribed. If a judge has given an order to execute, usually has given judgment, most likely the matter had not prescribed at the time of institution of summons, right? And summons would have interrupted prescription. But I think it's quite important to look a little bit more towards your Section 21 letters, your letter of demand.
Yes.
Looking towards whether or not the summons that was served on the domicilium address.
If it was a domicilium
If it was in fact a domicilium address. And by that we mean, did you put that address on your bond documents when you signed that bond? And under the clause which said domicilium setandi et executandi, did you say this is my address? I've chosen it. If you didn't, if you left that blank and you sent an email later and said, I'll be staying at this address or this will be my address, that's not for purposes of execution in terms of Rule 6, Magistrates Court in this instance, a domicilium address.
Absolutely.
Is that correct?
That would be true. So if the if the address where the summons was delivered by the sheriff is not your domicilium address and it does not confirm, there is essentially, your address is not confirmed on any piece of paper that you have with them, it is more difficult for service of the summons to be proven, and it is easier for the debtor to say that they never received the summons, and if they never received the summons,
that judgment is appealable.
Judgment is absolutely appealable.
Yeah. And also it's very important for viewers to remember that if you register your address with the bank as a domicilium and you happen to move and 2 years later you find there's a judgment on your name because you never notified the bank that you've changed your address, the onus is squarely on you to do so.
Absolutely.
So remember this, keep this in mind. There's a lot of ways that you can utilize the law to your benefit. And one of these things, for example, letter of demand, in terms of the National Credit Act, the bank has an obligation to send you a letter and give you a certain period of time to respond, and give you the option of a debt counselor, and give you the option of making settlement payment arrangements, and give you the option to tell the bank that you can no longer afford this. And if they don't, then they fall foul of the rules, and any judgment or action that is taken thereafter is essentially done in error.
Absolutely so.
Let's move on a bit
Just before we do though,
yes,
just something else I wanted to touch on. It's not just bond agreements where we put our domicilium address in. What I would like to put across to all the listeners here, well, the viewers here, is that there's no such thing as a standard agreement that somebody will just give you for you to sign. Any agreement that you get, you need to look through it and know what you are signing. And, well, now it's been pointed out, the domicilium address. That means if you give somebody a domicilium address, they can just automatically send letters there, and it is deemed as though you have received those letters.
Absolutely.
So that's why if you do move, it is very important for you to actually notify the people that you have agreed with and tell them that your domicilium has changed. This is to avoid actually coming back 2 years down the line and find that you have a judgment against your name because summons was issued on your domicilium address, as it is allowed to do, as allowed to be done.
Absolutely. Just a reminder, we are talking to Naeem Rajah. He's an attorney at MN Rajah, the director and founder of MN Rajah Attorneys. His email address appears, and that email address is Naeem, Naeem, at MN Rajah, Rajah spelled with an H, attorneys.co.za. The number that he would be contactable is 011 234 1143, and he's an attorney in Rivonia. We're talking general law. The lines are open. Call us 011 086 7700 12 or 3 and ask what you want. We will answer where we can. A tweet that's just come through, Naeem. Sorry, a tweet that's just come through relates to where a car gets stolen from a panel beater. There's no real criminal element there, if I'm not mistaken. What is the element? Where do we go? What is your rights in a situation like that? So you drop off your car at a panel beater, you come back to collect it a couple of weeks later, and the guy says, sorry, but your car's been stolen.
Well, I'm sure we all would know if you drive into any such company or business, panel beater, mechanic, etc., there is normally a sign on the wall that says, we will not be held liable for any loss due to fire, theft, damage, etc. In terms of the Consumer Protection Act, amongst other things, there are those non-liability things are of little value. They do, to a certain extent, waive liability, but it doesn't waive liability in its entirety. There are certain elements that you have to look for, and one of the main elements is whether there was any negligence on the part of the panel beater or mechanic where you have left your vehicle. So that would be the jumping off point. Obviously, it would be a civil claim, and when you look at civil claims, there has to be an act or an omission, so the omission would be perhaps not locking the gate, something to that effect.
Correct, yeah.
There's also the fault element, and fault could be either intentional fault or negligence. If somebody was negligent and where they should have acted and they didn't act in a certain way, they are liable because it was their fault. And in this regard, you can look and reclaim your damages from said person if they were indeed those kinds of elements.
Okay, brilliant. We've got a call on the line. Let's take this question. Assalamu alaikum. Good evening, caller.
Assalamu alaikum.
Wa alaikum salam, Mubarak.
Alhamdulillah, and yourself.
Alhamdulillah. I just want to ask you a question, and I know you guys just spoke about it just now.
Certainly.
I just want to put the TV off, respect firing.
Jazakallah.
Okay. I want to ask you, if you lose your house, you said that, I think you said that when the summons is taken out at court, that 3 years start from that date. You still have to pay the bank back, or don't you?
Okay.
So just to clarify, did I hear you correctly? If the summons is taken out at court, what happens?
Okay, well, the summons was taken out at court, and okay, the bank did say they sent us a letter which we never received. somebody came to the house and said, did the bank let you know? We said, no, the bank didn't let us know. We said, we should take it up with the bank. The bank sent a letter that they said they sent, but they never sent it. But that is the letter, because I mean, anybody can make up a letter. That is just how I feel. 3 years or 4 years went back after that, and then the bank starts saying, listen, you need to pay me back. I give you 5 years, and I start paying them. But I wanted to go to court. They left me. I told them, I'm going to take you to court. They left me. I said, I'm going to a lawyer. They left me. Every time I tell them, listen, I'm not paying you. I'm going to take you to a court. They leave me alone. 6 months go past. They again, listen, you need to pay us. I say again, I'm not paying you. So I just want to know, according to my rights as a person,
Yes.
I can't prove legally that what happened wasn't really true from the bank side. But when the summons was taken up, a period of time after that, the house was sold. We still lived there for about a year and a half, or almost 2 years, something like that, and then we moved. A year after that, I think I saw paid back. So about 220,000 that I still need to pay at that time.
Okay, Jazakallah for the question, caller. We'll answer your question off air. Jazakallah for that. Again, talking about repossessions, it's not a fun thing.
Absolutely
in this
not.
instant, the caller he's lived rent free for 2 years, so I mean he should be grateful. Just kidding. But seriously, though, jokes aside, what's important here? Is if that Section 21 letter was in fact delivered. And what's important, the caller made mention of, is that he can't prove that what the bank says actually happened, but it's not his obligation.
No, of course not. The general rule is that he who alleges must prove.
Thank you.
So if the bank does indeed rely on the fact that they sent the letter of demand, then they need to prove that. And that's why we do generally send letters via registered mail to avoid such eventualities. But if the bank didn't do that and they do not have any proof on their side with regards to issuing the letter of demand, which would initiate the collection process, well, like I say, they would have to prove that. And if they haven't done that, it would make this,
Sale.
Yeah, it would make the sale and execution to some extent appealable.
Yeah, absolutely. And of course, your judgment rescindable, obviously within the correct timelines and whatnot. But certainly, brother, I think contact Mr. Rajah. You can also Google his details, or if you type in Naeem Rajah attorneys, he comes up quite quickly. He's also on LinkedIn and on Facebook and all these weird and wonderful social media websites. Again, his email address is Naeem, Naeem, at mnrajah with an H, attorneys.co.za. The number to dial 011-234-1143, and he is in Rivonia in Johannesburg. We'll be taking another ad break now. When we come back, the lines are still open, 011-086-7700, or 1 or 2 or 3. This is Legalese. Assalamu alaikum, welcome back to Legal Ease, the show that converts legal jargon into legal ease. As I said before, we're speaking to Naeem Rajah. He's an attorney general specialist, a general law specialist, and he operates out of Rivonia in Johannesburg. His number, you can contact him on 011-234-1143, or on email, it's Naeem, Naeem, at mnrajah attorneys, Rajah is with an H, .co.za. We're talking general law. Ask what you want and we'll answer where we can. The phone lines are open, as I mentioned, 011-086-7700. Please phone in and we'll take your calls and answer them where we can. Just something that I want to prepare the viewers for. In the next 2 weeks, we're adding a new element to Legal Ease, at least on my show. It's going to be called, in one of the segments, it's going to be called Legal Easy Fix. All right, so it's a bit of a comical take on a quasi forum, so to speak, where we're going to pretend to be the judge and jury, and you could come with a family member or a friend where you have a relatively simple, not necessarily legal problem, and we will try and give you a resolution or a solution there and then on the show whilst you are both online. So we're going to try that next week. We're going to just watch out, look at our Twitter feeds. It's at ITV Legal Ease, and our Facebook, it's Facebook /ITV Legal Ease on ITV. And also you can Google us and you can find us on there. And also give us some of our ideas and we can perhaps maybe prepare for the show in advance. I think it would be a nice little humorous take on something that's otherwise a bit too serious sometimes.
Absolutely, and it will also give some people an avenue and an answer.
Yeah, so look out for it. Watch the hashtag. It's hashtag Legal Easy Fix. Inshallah, we'll try and fix the easy, simple problems that we might have amongst us.
Before it becomes a big problem.
Before it becomes a big problem. Thank you very much. We were busy talking about some general topics. One of the topics that I want to just touch on, base with you on, where are we here? All right. Consumers, clients, customers, a viewer rather, says they were a witness to an armed robbery. Do they have an obligation, one, to report it? And two, they believe that the docket went missing and now they're afraid that their name is in the docket, or that their name will be in the docket if they do go, in fact, report the crime. What would your advice be in this situation?
It is a bit of a tricky situation. I would start off by saying we're all up in arms about the high crime rate in the country. Mm-hmm. Unfortunately, there are too many of us who are too scared, or we don't feel we have the time to actually do something about it. When we see something wrong that's happening here, we complain, but we don't do. And here, with regards to this specific element, if you don't stand up and tell the court, go and stand as a witness and tell the court what you saw, there's a very good possibility that the person is going to get away with it and then is going to do it again on another occasion. So I would say that, yes, you do have a responsibility as a citizen of this country to stand up and help put the people who deserve to be behind bars. Yeah. And yes, there are certain pitfalls in within our country, within the policing systems, etc. We do hear about dockets going missing, etc. But so to the best of my knowledge now, the dockets as they are being opened are generally scanned in. So although the actual cover of the docket may not be easily replaceable, the contents of the docket are. And that does make it quite a bit easier for the prosecution to reopen cases and readdress cases and
hopefully keep these
and have the matter finalized.
Yeah, yeah. I just want to, to cut you off. I just want to make mention of an error that I made, and I don't think either one of us picked it up. I apologize for that. Is the letter of demand that I was referring to is not Section 21. I've just been dealing with a Section 21 company recently. I'm so sorry. I apologize. It's a Section 129. It's Section 129 of the National Credit Act. And I sincerely apologize. I got that. I was just thinking about the wrong thing. And I apologize. The letter that I'm referring to that you have to receive from the bank in accordance with the Act is a Section 129 letter, not a Section 21. Section 21 relates to something completely different in terms of the Act, but also a company. That I was dealing with Section 21 company.
And that's Section 129 of the Creditors Act, to the Credit Act.
National Credit Act,
National Credit Act,
NCA.
yes.
I apologize for that, just keep that in your memory. Not Section 21 letter, you're never going to get a Section 21 letter. It's going to be a Section 129 letter, so please just keep that in your mind. So none of us, he might have, he's probably just too kind not to
I thought you might have been saying something that I didn't know about. So.
No, I'm certain you know more, if as much as not more than me.
We learn.
We've got another caller, Naeem. Let's take this caller. Assalamu alaikum. Good evening, caller.
Assalamu alaikum.
Hello.
Yes,
Hello.
assalamu alaikum. You can go ahead.
Good evening. My name is Shayna.
Yes, Shayla.
I just wanted to ask her a question dealing with legal ease.
Yes.
Okay. My auntie is a widow. That means that her husband is deceased. And the title deed that she has her husband's name and her name on it. So what I wanted to know was, if my auntie happens to pass away, what will happen to the house?
Okay.
Right.
Okay, Jazak. Thank you very much for the question. We'll answer your question off air. Thank you very much.
Well, I would imagine that the auntie and uncle were married in community of property.
Well, let's assume for the time being that they were.
For these purposes, we'll assume, okay, so they're married in community of property. So even if the house itself wasn't in both their names, they would both have been the rightful owners of that property.
And obviously, matrimonial property regime takes precedence over any testamentary.
Absolutely. Before we get to the will, you actually need to see what that person owned. So we are also assuming that her husband has passed away, so she's now
She's a widow, yes.
So she's a widow, so she is the primary owner of that property. And if she is still alive, I would suggest that she make a will. And if she is
Obviously, lay claim to that property because certainly, if in fact it was married in community property, she owned 50% of that property automatically.
Absolutely.
Assuming she wasn't married in community property, assuming she wasn't married at all, assuming they were just life partners for argument's sake, and there was no will.
So if she passed away and there was no will, or if he
passed away, she's the widow, so he passed away, and she now, for all intents and purposes, his family comes knocking on the door saying, "This is our house, get out."
Well, obviously, she is entitled to 50%, as we've discussed now.
That's if she's not married. I'm in a situation where now they're not married at all. They were just living together. But they've been living together for 20 years, and remember that life partner rule.
Oh, the life partner rule
has essentially fallen away, in our act. But there is a situation where, remembering also that whatever she's put into the property, she has a claim for. Whatever improvements she's made into the property, she has a claim for. If there are any permanent fixtures or fittings, she has a claim for that property. Because bearing in mind, she did it with the consent of the owner. So if they weren't married, essentially, the estate of the owner, who was essentially her husband, but in this instance they were married. So, but assuming they weren't,
just to cut in there, I apologize. The question did say the deed of suretyship. The actual deed has both their names on it.
Oh, the deed of the title deed.
Title deed.
Okay, well, I mean that's
their names on it.
Clean and cut.
So that does make it so a bit easier.
Yeah. But then again, remember, it's only for 50%.
Yes.
You understand? But
absolutely.
She did say she was a widow, so she was essentially married. And if she was married, then we'd have to determine how.
Right.
And if it was out of community of property, whether or not there was an ANC. And if there was an ANC, what did the status of the accrual say? Because remembering also that the accrual must be given preference to before any will or testamentary claim or bequest or etc.
Right. So going back to the question, if something had to happen to the aunt at this stage and there was no will left behind, the entire estate would be distributed intestate. And there are specific set out rules by which estates are divided if no will was left behind. So essentially it would go to the nearest family members, being the children, and if not children, parents. If not, then it goes sideways to the aunts, uncles, cousins, etc. So with regards to this caller, you are in a position where the aunt is still alive. So it would make the most amount of sense for her to sit down and draft the will, and then so that her actual wishes can be seen through in the event of her passing.
Yeah,
that is the best advice that we can give you, just to avoid
that effect, on those facts.
Yes.
So thank you. We've got another call on the line. Good evening. Assalamu alaikum, caller.
Wa alaikum salam. I just wanted to get a bit of clarity on, it's an insurance case that I have.
Okay.
This happened in 2006. I just wanted to find out in the clause when I took out the insurance policy, they had asked me if I had any incidences or accidents in the past 3 years, and I said no. And I had thought they were talking about the particular car that I was insuring. And later on, I do, as the questions go along, I do disclose that I had a car stolen from me. I was in an accident before that. And the insurance agent didn't say, you just said that you didn't have any accidents or incidences. And that's where I feel that I wasn't trying to hide anything, because I did disclose that I did have those accidents or incidences.
Yes.
But just that it was, I was thinking about that particular car that I was insuring at the time.
Right.
Because
Okay.
it is going to court and...
Yeah,
so-
it can be a tricky issue because you've essentially suffered a loss, and the minute you've
Yeah.
suffered a loss and you've been paying a premium, there is a right of recourse and there is an avenue that you can utilize. Sister, we'll discuss your question off air, and you can listen to us off air essentially.
Okay.
Jazakallah.
Jazakallah so
Jazakallah.
much.
Naeem, I'm not an insurance specialist, but I have essentially dealt with a matter very similar to this. What's your experience with these types of insurance matters? Because bearing in mind, that document that you receive, I mean, it's quite confusing.
It is indeed, especially for the lay person. The thing is, you have to also look at it from the side of the insurer. Your premium is calculated based on the information that you provide to them.
A risk perspective.
The risk, yes, the risk analysis. So to some extent, they are justified in repudiating certain claims. By repudiating, I mean not honoring certain claims because they haven't been charging you enough on a monthly basis based on the information that you gave them. One of the questions I would have asked is whether or not you told them about your previous accidents prior to you having to claim or after, because if it was prior, that would have remedied on their part.
It sounds like when she was taking out the insurance.
The information was given when she was taken, when
Yes.
when the insurance period was taken out, but she also did mention that it did come out at a later stage.
In the form that she was filling out, essentially, it came up again where they asked if she had previous accidents, in which she did say then yes, she did. So she obviously misinterpreted the first part of the form or the questionnaire, and then later on realized, answered the question truthfully when she kind of understood it.
Right.
So in a situation like that, she did make correct disclosure. It might not have been at the correct time, but she certainly did make a correct disclosure. If they calculated, like you said, the premiums based on her risk as not being a risky person because they didn't take into effect the first 2 or 3 or 4 questions, they're experts. They should really make more of an informed decision.
That is indeed true. And then in that regard, where there is actual grounds on which you can rely, where you did give them the proper information at a latest when it was possible for you to do so, then the normal principles of contract would come into play.
Absolutely.
Whereby you have paid for a service and you expect to receive your benefits from that service that you've been contributing to.
Sister, I advise contact Mr. Rajah on 011-234-1143. That's his Johannesburg office. You can also email him at Naeem, Naeem, @mnrajah, Rajah spelled with an H, attorneys.co.za, and inshallah he can be able to assist you a bit further. We've got one more call on the line before we wrap up, Naeem. If you can believe, we're almost at the end of our show.
Already?
Let's take this call. Assalamu alaikum, good evening, caller.
Hello, how are you?
Good,
Well,
thank
thanks
you.
to yourself.
I'm fine. I just want to ask, is it possible to change from in-community of property to out-of-community of property, meaning like to change the marriage regime status?
Yes. Okay. Okay.
The reason for that is like I'm married in community of property and at the moment I'm doing like everything alone and I just find out that my husband is cheating, so I'm looking forward to the business, so I'm not really trusting anymore because I'm just doing everything by myself now.
Okay, thank you very much, sister. We'll answer your question off air. I mean, I don't know if you noticed me wince when she said I would like to change my matrimonial. I mean, I don't need to tell you, it is extremely difficult.
Although it is possible. Let's put it that way. It is possible that is catered for in
And I know what the but
legislation.
is coming. I can hear it coming.
Yes, there's a big one. The courts do not enjoy granting that order.
And especially on the motivation, which she has essentially stated that she wants to do it. She doesn't trust him anymore. She believes he's cheating on her. She wants to change the matrimonial proposition. The quicker avenue is to divorce him, and if in a couple of months' time you believe that you want to get back together with him, then marry him again, but marry him out of community of property.
There we go.
But you certainly have grounds for divorce.
Indeed, and
Loss of love, loss of respect, break of matrimonial of trust, sort of breach of trust.
Absolutely.
You have grounds for divorce. Rather
irretrievable
divorce the man,
breakdown.
And if you feel you want to get back together with him at some or other stage in the future, get married to him again, but do it out of community property. Contact Naeem Rajah attorneys, and they'll draw up a very good, airtight ANC, which hopefully when he does it again, you'll stand to win a lot more money, to gain a lot more money.
But aside from that, I think what the lady was asking was, because if she goes the divorce route, I think she fears having to give half of her property through to him. But under these grounds also, it can be, you can ask the court to have him, what's the word I'm looking for here, where he loses his
right. So waiver of entitlement.
Yes, exactly. So he loses entitlement to the
property, the assets,
to the joint estate, essentially,
yes.
by virtue of his conduct. He has acted in a way that has led to the ruination of the marriage, and this should be put forward to the court for him to actually lose his benefits.
Certainly. Contact Naeem Rajah, inshallah he'll be able to assist you further. We've got one more call on the line. I can hear the phone lines are ringing off the hook, and it's almost at the end of the show. Let's quickly take this one, Naeem. Inshallah we can get through it. Assalamu alaikum, good evening, caller.
Assalamu alaikum.
Walaikum salam. May I pose a question, please?
Ji.
I'm a 50% shareholder in a CC, in a franchise business.
Okay.
Okay. Because of problems in association with the present partner, I wish to sell off my shares in the CC.
Okay.
Can I sell off the shares without without the present partner's permission?
Okay. Thank you. Is that the question?
Yes, sir.
Okay, Jazakallah, we'll discuss your question quickly.
Jazakallah.
Just obviously there, very quickly, before we even get into the bulk of the question, he says CC.
Yes, it'd be members rather than
a member's interest as opposed to a shareholding.
Indeed so.
Okay, so you've got a member's interest, and bearing in mind, obviously, the members' interests are directly attached to the members. So unlike with the shareholder, you could be a director, or a PTY rather, you could be a director, but you don't necessarily have to be a shareholder, or you could be a shareholder and not necessarily be a director.
Indeed.
In this instance, your advice to him? So he wants to essentially now sell off his shares in the member's interest. Should I say sell off his members' interest, so to speak, in a CC. Bearing in mind, obviously, that he mentioned an association agreement, an agreement of sorts between the members. So they were obviously in association. And if they are essentially in association, it most likely makes provision for the fact that you cannot sell your members' interest without the consent or give them the right of first refusal. So you're giving your other co-members the right of first refusal to sell your members' interest. Bearing in mind that it has to be quantified and evaluated as to what those members' interests are actually. But he says 50%, so essentially there's only one other member.
Yes.
In which instance, if you do have an association agreement or you do have some or other document regulating your transaction between the two of you, you would have an obligation to get his consent. Alternatively, you'd have an obligation to sell that member's interest to him first. Am I correct in saying that?
That's indeed so.
I think very important, caller, if you want to contact Mr. Rajah, Naeem at mnrajahattorneys.co.za or 011-234 1143. His firm is in Rivonia in Johannesburg. You can find him on Google, MN Rajah Attorneys, and bring him that association agreement, bring him your CK docs, let him take a look at that and see if perhaps maybe there is something that can come through. I think we're going to have one more caller, if I'm not mistaken. We've lost that call. Okay, Naeem, we're at the end of our show. Unfortunately, it's been an absolute pleasure having you on the show, and I think that by the sound of the amount of calls and the tweets, we haven't even gotten through half of the tweets. We've actually still got about 4 or 5 tweets that were pending, but you've been phenomenal. Thank you very, very much for coming and for cancelling your plans. Really, really appreciate it, and I'm sure that the viewers have received a lot of insightful information.
I hope so.
On Legalese, the show, as we mentioned, that converts legal jargon into legalese, and this is what we try and do on a weekly basis. You can catch us on a Thursday night, as you know, at 8:30 on this channel, ITV channel 347. Don't forget, inshallah, in 2 weeks' time, we're going to be introducing Legal Easy Fix, a bit of a comical take, or a humorous take, should we say, on an otherwise more serious situation. We hope that you've enjoyed the show. We hope that you've achieved, that you've obtained some knowledge. Remember, as I mentioned at the start of the show, you have an obligation to look and search and learn for yourself and educate yourself and make sure that the information you receive is in fact accurate. As you heard, I can make mistakes. We are all human, and I apologize once again for that. Inshallah, we'll see you all again next week. Jazakallah for joining us. Jazakallah to Naeem Rajah, Naeem Rajah Attorneys, MN Rajah Attorneys. We'll see you all again next week. Assalamu alaikum wa rahmatullahi wa barakatuh.
Assalamu alaikum wa rahmatullahi wa barakatuh.